Thank you, Angelina, for the introduction. So we're here today to talk about HIV criminalization, providing an update on legal aspects. I'm going to provide a global overview, and then Michaela is going to talk about the impact on women. Then I'm going to examine how U=U has impacted HIV criminalization, and then we'll discuss together whether U=U is the most useful frame for advocacy to end HIV criminalization. So what exactly is HIV criminalization? Well, we define it as the use of vague and overly broad HIV-specific criminal laws and or the unjust application of general criminal or similar laws to people living with HIV based on our HIV positive status. And it's increasingly being recognized as an important public health and human rights issue because too many people living with HIV are being convicted of such crimes, contrary to international guidelines on HIV and human rights, as well as contrary to scientific evidence, medical evidence, and best public health advice. In short, HIV criminalization is a triumph of stigma over rationality and science. Now, HIV criminalization laws usually single out HIV, which is inherently stigmatizing. They can be applied to all kinds of behaviors that don't lead to an HIV risk. And the laws often use the term deliberate or intentional without any further definition. And this is usually interpreted in a way that conflates the desire to have sex with the desire to infect. And prosecutions often allege HIV exposure even when this is not possible, and or HIV transmission, even when this cannot be proven beyond reasonable doubt. And if someone is found guilty, this can also lead to disproportionately long sentencing compared to other similar risks or harms. As you can see from this map of the world, HIV criminalization is a global phenomenon. Now, in 2019, UNAIDS reported that 92 countries had such laws, but our most recent analysis of our data from the Global HIV Criminalization Database, which we update in real time based on constant monitoring, suggests that it's nearly 130 countries. So we have 50 active countries. These are the countries that are in red that have reported cases since 2017 using any kind of criminal or similar law. And then there's another 60 countries of concern. These are countries that either have or are proposing HIV-specific criminal or similar laws. And then there's a further 20 that haven't used, done prosecutions recently, but we want to keep an eye on them. So that's a total of 130 countries globally. In 2020, we documented at least 90 cases of unjust HIV criminalization in 25 countries, that's just in 1 year, with Russia and the United States being the worst offenders. And women living with HIV were accused in 25% of those cases. Now, there is no one typical HIV criminalization law, although most HIV-specific criminal laws are overly broad and are also too vague, and they don't allow defenses that reflect up-to-date understanding of HIV science, including U=U, and we'll talk more about that later. So international guidelines on HIV and human rights, as well as UNAIDS and the Global Commission on HIV and the Law, don't recommend using HIV-specific criminal laws at all, but instead recommend using general criminal laws, but only for the most egregious behavior, which would be malicious, intentional transmission. However, many prosecutions are taking place under general criminal or similar laws, such as laws like grievous bodily harm, reckless endangerment, or public health laws. And most of these cases that we have been monitoring involve an HIV positive person having sex where it's alleged they didn't disclose their HIV positive status. And some cases involve people with HIV even when they've disclosed and their partners have consented to the risk. But the problem is how do you prove you disclosed if the partner is, for example, retaliating after a relationship's ended? Some cases involve spitting or biting or even throwing used sanitary towels, as was a case recently in the UK. And there have been prosecutions for vertical transmission and more recently for breastfeeding. And Michaela will talk about that in a moment. Many of these cases involve potential or perceived exposure only, and no HIV transmission is actually alleged. And many cases also involve no or negligible risk. Either condoms were used, the person had a low or undetectable viral load, the sex was just oral sex, and also, as I've mentioned, there's spitting or biting. There are also faulty assumptions of guilt where transmission is alleged, and that's because the first person diagnosed in a couple is often considered to be the first infected, and that's usually a woman. And also there's a limited use of phylogenetic analysis, which can exonerate a person if the samples don't match. But that's rarely used. And even when it is used, the results can be misinterpreted. And so among the thousands of known prosecutions that we're aware of, cases where it was proven beyond reasonable doubt that an individual wanted to infect another person with HIV are unusual and extremely rare. So in summary, HIV criminalization is about selective and arbitrary prosecutions, improper and insensitive police investigations, limited access to competent defense lawyers, there's disproportionate sentencing, and then on top of that, there's insensitive and stigmatizing media reporting, which just perpetuates the stigma. So no wonder HIV criminalization is a barrier to HIV prevention, treatment, and care. So now I'm going to pass over to Michaela, who's going to talk about how HIV criminalization has a disproportionate impact on women.
So thank you, Edwin. Criminalization, HIV criminalization, as you've mentioned, does disproportionately impact women. Way back in the early 2000s, 2003, 2004, somewhere around there, we had an incredibly interesting meeting in Johannesburg, in Southern Africa, where I come from. And it was a meeting to examine the issue of HIV criminalization, which was pretty new in those days. And what was interesting about that meeting was that at that time, the calls for laws that criminalized HIV transmission, exposure, or non-disclosure were really coming from women's groups, from women's civil society groups. And it was, in a way, it was understandable in the sense that women obviously were scared and frustrated about the fact that they were becoming infected within their relationships. In relationships where the balance of power is completely skewed, where women don't have the ability to enforce safer sex, who often get to know their HIV status first, as you mentioned, because of attending antenatal care, and then find out that they're HIV positive and come back to the home, but then find that they can't disclose that to their partner because of a very real fear of being beaten up or thrown out of the house, often a household where the woman is completely economically dependent on the man. And then at the end of the day, it's the woman who's blamed for bringing HIV into the house, which obviously is severely problematic in the sense that not only do they face rejection and being thrown out of the house, but very often they are the people to be first prosecuted. So women are very often first in the firing line when it comes to prosecution. And when we had this discussion and people started realizing that this was the case, it was like, well, maybe HIV criminalization is not such a good idea for women, because at the end of the day, it's going to be women who are on the receiving end of these criminal laws, which was not what people had thought about initially. And just to illustrate with a couple of cases, in Zimbabwe in 2010, and this really illustrates the sort of completely different motivations for prosecution, which, as Edwin has mentioned, very often and very rarely are cases where there was any kind of malicious intention to transmit. So in Zimbabwe in 2010, a woman was arrested by the police. She and her husband had recently got divorced, and he was seeking revenge. And he, by seeking revenge, told the police that she'd infected him with HIV, which in Zimbabwe is a criminal act. that can carry a prison sentence of up to 20 years. There was absolutely no evidence that she had infected her husband, and yet she was convicted in 2012 in a magistrate's court of lawfully transmitting HIV to her husband. And this was because the law in Zimbabwe is so incredibly broad that it covers it covers even people who don't necessarily know that they're HIV positive, but who believe that they may be HIV positive and haven't disclosed to their partner. And also, as you can see from this case, didn't require any kind of proof of her being the actual person who transmitted HIV to her erstwhile husband. So that's a very disturbing case from Zimbabwe. And then more recently in Malawi, we see a case where a woman was at a village meeting, surrounded by other women. They all had babies. All the babies were sitting on each other's laps. And the baby that was sitting on her lap started breastfeeding from her. She didn't realize it wasn't her own child. She didn't intentionally breastfeed somebody else's child. It was just a mistake. It was totally unintentional. And yet she was convicted of a crime under the penal code in Malawi for breastfeeding another person's child. The child never contracted HIV, although she was HIV positive and on treatment. The child didn't contract HIV, and the evidence indicated that the breastfeeding was completely accidental and negligent. The state failed to introduce any evidence to prove the likelihood of transmission with breastfeeding. And yet this woman was found guilty and sentenced to 9 months imprisonment with hard labor, which is also, again, completely outrageous. And then, Edwin has referred to the issue of the media and how the media can really exacerbate things with sensational reporting. I mean, and to illustrate this again, there was a case in Uganda of a nurse who was over 60 years old. She had 35 years experience as a nursing sister. She was trying to give an injection to a child who was sick, a 2-year-old who was struggling and kicking and screaming. And in the process, she pricked her finger with the needle. When this happened, she was living with HIV. When this happened, she stopped completely what she was doing. She washed off her finger, she bandaged it, and then she went back to the child and administered the injection. Now, the mother then was uncertain about if the same needle had been used throughout and that the child had been exposed to HIV. The child was tested, was negative. She was arrested in front of a crowd of journalists. The arrest was completely orchestrated to have as much media attention as possible. She was charged with attempted murder. The media reports after she was arrested were absolutely outrageous. She was found guilty in the court of public opinion even before the trial had begun. There were articles that, for example, led with the heading, "Killer Nurse Charged with Attempted Murder," went on to accuse her of maliciously infecting patients, mainly children, with her HIV blood. She was convicted of, eventually, after being charged with attempted murder, they toned the charges down. She was convicted of negligently exposing a child to HIV and was sentenced to 3 years imprisonment. It was taken on appeal, and after that, she was released after 10 months. But she still sat in jail for 10 months for allegedly exposing this child to HIV. And these are really just illustrations of how outrageously broad a number of these laws are, and how they are often targeted at women, and how they end up in convictions and sentences that are completely disproportionate to the harm that was ever caused or not, as in many cases, and targeted specifically at women. So I'm going to hand back to Edwin at this point to talk a little bit about U equals U. So back to you, Edwin.
Thanks, Michaela. So you can hear how incredibly unjust HIV criminalization is and can be, and particularly how it impacts women. And so a lot of the work that we have been doing with colleagues at the HIV Justice Network is to obviously try to mitigate the harms of HIV criminalization. And one of those ways, of course, is ensuring that up-to-date science is understood by the criminal justice system and by lawmakers. And this isn't a U equals U session. So I just did an analysis of where U equals U has had an impact on HIV criminalization. And the reality is that it's really only had an impact in 20 jurisdictions in 15 countries. And all of these are either in Western Europe or North America, except for Morocco in North Africa. So you may all, of course, be aware of the Swiss statement of 2008, which was the first time there was any kind of consensus, at least from within a country, about the prevention impact of treatment. And the statement was written as a reaction primarily to the overly draconian law in Switzerland, which at the time didn't allow people living with HIV to even disclose and consent to the risk. And there were many unjust prosecutions. And a year later in 2009, the District Court of Geneva actually ruled, having been influenced and impacted by the Swiss statement. And that led to prosecutions no longer happening in Switzerland for people who were on treatment and undetectable, and the law actually changed subsequently. But the first country in the world to actually recognize the prevention benefit of treatment was actually the Netherlands, which is where I'm currently living. And that was in 2005 when the highest court in the Netherlands actually appreciated then that the risk for someone who was on treatment wasn't high enough for the criminal law to be applied. And across primarily Western Europe, U equals U has had an impact in a number of ways. It's been incorporated into prosecutorial guidelines in both England and Wales in 2011 and in Scotland in 2012. Spain also recognized, so only a lower court, however, recognized it in 2012. And then in Finland, 2015, a Supreme Court ruling recognized U equals U. In Sweden, 2016. Germany, 2017, the same year as Italy. The law changed in Norway in 2017 that actually specifically removed people who were undetectable from the purview of the criminal law. In other countries across Europe, it's been court decisions, either lower courts or Supreme Courts, such as the Supreme Court of the Czech Republic in 2018, a lower court in Greece also in 2018, a high court in France in 2019. If we move to the next slide, looking at North America, there has been some change there. The changes are slightly different there. Across Canada, there's been a number of directives, prosecutorial directives, that have begun to recognize the prevention benefit of treatment from around 2017, although problematically, Canada's Supreme Court in 2012 ruled that you needed to have both a low viral load, that was below 1,500 copies, and use a condom in order to preclude yourself from the purview of criminal charges if you didn't disclose. And the battle there continues, and there are still prosecutions in Canada even for oral sex or sex with a condom, as well as people who are undetectable in lower courts, and the battle continues there. Across the United States, a number of states have begun to recognize the prevention benefit of treatment. And there the term is being used to modernize laws. There are currently 32 US states with HIV-specific criminal laws, many of them written in the 20th century, although some have actually been enacted more recently, that are completely out of date with science. So the law has changed in a number of US states. The best example would be California, which completely removed HIV criminalization as a crime and basically made it a misdemeanor. And there, only intentional transmission is prosecuted. But in other states, for example, in North Carolina and in Iowa, the law changed that specifically mentioned U equals U as a defense. And the problem there is that since then, particularly in Iowa, we've seen people still be prosecuted who either haven't achieved an undetectable viral load for one reason or another, or haven't been able to measure it recently. Globally, we worked with UNAIDS, IAPAC, and the IAS to help support 20 global experts in HIV science to produce the expert consensus statement on the science of HIV in the context of criminal law. This was published in 2018 and launched at the AIDS conference then. And we expected this to be a key reference for clarifying the important issues of HIV science in the context of criminal law. Of course, including, of course, all the information we have around U equals U. But the way it was framed in a very specific way that didn't only talk about zero risk with someone who was undetectable, but actually framed risk in a different way than public health frames risk. Public health frames HIV risk as sort of high, medium, and low. From a criminal law perspective, when you're actually looking at individual potential exposures or transmissions, you're actually looking at a per act risk. And there the risks were framed as low, negligible, or none. And certainly as far as a lower undetectable viral load, the risk was there described as either negligible or none. I'm now going to ask Michaela to come back so we can actually have a conversation now about whether it actually is useful in our advocacy to end HIV criminalization to actually focus only on the science and particularly on U equals U. So welcome back, Michaela. We've had conversations, many conversations together about the potential problems, the pitfalls of using U equals U or talking about the science of risk in our advocacy to end HIV criminalization. Can you outline what your major concerns are?
I think for me, the biggest problem is the inequalities that are faced around the world, but particularly in the region where I live in Southern and East Africa, in terms of access to and retention on treatment. And I was just looking at the stats just before this presentation, and I think, you know, what's interesting, for example, is that in East and Southern Africa, 72% of people living with HIV are on treatment, and of those, only 65% are virally suppressed. Whereas if you compare those figures with Western and Central Europe and North America, you've got 92% of people living with HIV on treatment, and 82% of those are virally suppressed. And there's a reason for that, and it has to do with inequity and inequality and access to treatment. There are many reasons why. It has to do with the cost, it has to do with distances, it has to do with you know, a number of issues that are not faced by people in other parts of the world. So for me, inequality and equity is a really big problem with relying entirely on U equals U, you know, as an end to HIV criminalization. Back to you, Edwin.
And I would argue that those disparities are not just in your region, but in fact, even across the global north, there are disparities. There are marginalized people who don't have access to antiretroviral therapy or are unable to remain on treatment. And so whilst U equals U can be used as a defense in an individual case, we really would argue against including this in modernized laws as a particular reason why someone shouldn't be prosecuted. And the reality is that science alone is never going to be sufficient to end HIV criminalization. It's important, but it's not enough. And the criminal justice system and law and policymakers have to also consider the impact of prosecutions on the human rights of people living with HIV. And we all need to focus on public health efforts, as well as supportive laws, enabling laws that support women and everyone living with HIV to live their best lives, rather than relying on people living with HIV making us the scapegoats for HIV prevention globally. And so I hope that that's a useful framing for you, and we look forward to your discussion.